Good afternoon, everybody. Michael Smikun here from Callagy Law, coming to you live yet again for one of our webinars. And what we're working on today is helping some of our in-network and out-of-network medical providers understand a little bit about the lay of the land in light of some recent changes to the law governing self-funded health plans. So that's ERISA-governed health plans. So what I'd like to do is kind of go through it a little bit, explain to you a little bit about the changes in the law and how it'll impact you, and making sure that you guys have all the resources that you need to ensure that you're maximizing your reimbursement. So again, this is Michael Smikun from Callagy Law. I'm one of the attorneys here and a partner with the law firm. And I'm here with my support team that's helping me bring this to you live. So, you know, the title of this webinar is Evolve or Perish, Episode 2, stealing a little bit from some Star Wars references here, because in a lot of different ways, the insurance companies have acted like the evil empire, and we are the rebellion, making sure that you guys are being taken care of and that your reimbursements are as high as possible and that there's law and justice on your side and fairness in terms of helping you to do your job. So the main topic of conversation is going to be this Third Circuit decision that came down towards the end of May. So it's a little bit over 2 months old at this point. And it's been a pretty groundbreaking case with huge implications. And unfortunately, not many medical providers really know what this case is and what the implications are. So we're going to go through that right now. And so just by way of brief introduction, the decision that I'm talking about is a case called American Orthopedie Sports Medicine. It was a case that we had taken from the district court level, which is the lowest level court in the federal court system, up to the Third Circuit, which is the appellate court that governs Pennsylvania, New Jersey, and Delaware. You know, the circuits are spread out across the country, and it's the court right before the United States Supreme Court. And so the decision really has turned the tide in a war that's been being waged by out-of-network providers and insurance companies, which are acting in the role of what's referred to as a claims administrator as it relates to these self-funded health plans. And really what the American Orthopedic case stood for, what it actually addressed was this question about whether or not anti-assignment clauses are enforceable. And so one of the questions folks have been asking is, what exactly is an anti-assignment clause? Why does this even matter? And you know, what's new about this decision? And so the anti-assignment clause is something that is contained inside of the plans of self-funded health plans and employer-sponsored health plans that are governed by ERISA. And so I'll talk a little bit about this more. You have the fully funded health plans. That is, you obtain a policy of insurance directly from Horizon, and they write a policy, they underwrite it. That's a fully funded health plan. On the other hand, you have an employer-sponsored health plan, which is an employer, rather than pay premiums for a policy, will set aside a certain amount of money to pay for the health insurance claims of their employees, and those funds are administered by third parties, people like, or entities like Horizon, Cigna, Aetna, and things of that nature. And so these plans, right, these plan administrators prepare these plans, and inside the plan is a provision called the anti-assignment clause. So how does the anti-assignment clause work? Well, almost all out-of-network medical providers at this point should be fully aware of what an assignment of benefits is. But basically, an assignment of benefits is a legal contract between a principal, also known as the Assignor, that confers standing to a third party and gives them the ability to collect on certain benefits. In the context that it provides or relates to medical providers, is a policy of insurance, right? The patient is entitled to benefits under that policy of insurance, and they assign those benefits over to the medical provider that's providing the services to them to collect those benefits directly, rather than have the patient, you know, submit health insurance claims forms and try to collect directly against the insurance companies. You'll actually have the doctor file claims on their behalf. And so these plans and these self-funded health plans will have what's referred to as an anti-assignment clause that basically says, words to the effect of, to the extent you try to assign your benefits out to anybody, right, doctor, whatever, that policy or that assignment of benefits is voided by agreement. And so if you're looking at the slide, you'll see the reality is there's nothing agreeable about it. The patient doesn't negotiate their contract. And for many employers, right, and I'm gonna go on a limb and say the overwhelming majority, the lion's share of employers have absolutely no idea that this provision is even in there. They don't even know, they don't care. And so these are basically just contracts that are presented to them, and they don't fully understand the implication of this clause. If they did, they'd try to negotiate out of it if the insurance companies and the plans would even allow them to do that. The reality is these are jammed into contracts on page 62 of an 87-page document, which nobody reads. But that provision basically prevents your assignment of benefits. And now, many medical providers are going, wait a second, that's how I submit my insurance claims. That's how I get paid. Yep, that's exactly what the anti-assignment clause's purpose is to prevent you from getting paid on your out-of-network claims. And so, the best way to liken it for me is that this is the Death Star, right? This is your planet destroyer. This is the ultimate weapon that the insurance companies were using against the medical providers to defeat their claims. And again, this relates to self-funded health plans and employer-sponsored health plans, which is the overwhelming majority of the claims that out-of-network providers are submitting. There's some doctors that focus entirely on PIP or a large part of their practice is on PIP or workers' comp. This doesn't apply to that. But this, in the out-of-network context, in the commercial insurance context, self-funded health plans and employer-sponsored health plans form the majority of the types of claims that you guys are all submitting. So this is the ultimate weapon against them. And we have been fighting tooth and nail to gain ground against these anti-assignment clauses. But by and large, the courts, the district courts, have been holding them to be enforceable. And it's been a challenge. So, in comes the Third Circuit decision, and it talks a lot about powers of attorney, right? The latter part of the decision, which I'll get deeper into, this is kind of just an introduction, talks a little bit about power of attorney. So what exactly is a power of attorney, and how does it relate to an assignment of benefits? Where an assignment of benefits confers the right to a third party to stand in the shoes of the person who conferred the right, in this case, the patient, to stand in the shoes of the patient, a power of attorney doesn't actually do that. What it does is it confers the right to take action on behalf of that party, in this case, the patient, right? And so power of attorney, just broadly, it's a legal document, right? It allows one person to act on behalf of another person, and a legal relationship is formed with its own duties, fiduciary responsibilities, and things of that nature related to the scope of the power of attorney. And it's a principal, right? In this case, it would be the patient who appoints an agent, right? In this case, it would be the medical provider, to act as something called as an attorney in fact, right? And so a power of attorney specifies the powers you give to your agent. It could be limited, it could be broad, it could be for specific purposes. In this instance, we're advocating the use of powers of attorney in a very specific context, and I'll get more into that. But basically, as a result of this Third Circuit decision, which I'll explain a little bit more shortly, whereas you had the Death Star, which was the ultimate planet killer, the ultimate weapon that was being used against the medical providers to defeat their claims, the power of attorney defeats them, right? It's literally the Third Circuit's way of saying, hey, insurers, if you thought you were going to get away with these anti-assignment clauses and preventing medical providers from having standing and pursuing their claims and making sure that they were getting 100% of the reimbursement, you are mistaken. That's the exact words that the Third Circuit used, that the insurers are mistaken in this regard. And so the Third Circuit has spoken very loudly on this issue. So, let's dive right down into the meat of all this fun stuff. So what are we advocating for today, right? In the same way we discussed the out-of-network legislation and the need for medical providers to evolve their practice if they want to survive in this changing climate related to out-of-network reimbursements and things of that nature, it's time to evolve, right? So again, just like the out-of-network legislation, which impacted fully funded health plans, this impacts the self-funded health plans, which is the majority of the reimbursements that you're seeking. And in this case, you need to change your practices, right? There's certain additional documents that need to be added to your patient intakes. That is a HIPAA release form. Many of you already obtained those when you're signing up a new patient. But there's also another document called an Authorized Representative or Personal Representative form, which is there's a template form that you can use, which we're happy to provide to you guys. But each one of the insurance companies also have their own forms, like the Horizons, the Aetnas, the Cignas, things of that nature. They have their own forms that you can fill out and become the authorized or personal representative for, which gives you certain powers which you'll need to help you in terms of your collections and making sure that you're maximizing your reimbursements. And then, as I said, kind of the bulk of this conversation is the power of attorney, right? I am not advocating for the removal of the assignment of benefits, because the assignment of benefits still serves a very important part of the things that you do. The assignment of benefit is still enforceable in fully funded health plan cases. It's still enforceable in PIP cases. It's still enforceable in workers' comp cases. Government, state government run health plans, your firefighters, police officers, teachers, things of that nature. Those assignment of benefits are still valid, they're still enforceable, and do not stop getting assignment of benefits, but your intake should be supplemented with these additional materials as well. So, one of the questions that we're asked a lot by our clients when we start to discuss this American Ortho case, which came out in May of 2018, it's a decision that we're very proud of, but one of the questions that we're asked a lot is, will this impact all of my patients, right? How many of the patients will it impact? The truth of it is that if you have a nice breakup and diversity in your practice in terms of how you do your out-of-network services, you have a little bit of PIP, you have a little bit of workers' comp, and you probably have a lot of commercial insurance claim, private insurance policies and things of that nature. This will only impact not the fully funded policies, which I'll explain in just a minute, and how to identify the difference between them, but this will impact the self-funded policies, which by and large statistically is the largest population of your out-of-network claims that you're submitting. And if you don't know that to be the case, that's probably because it's intentionally obfuscated, it's intentionally confusing to give you guys a hard time in figuring out what your rights are. It's easy to obtain a policy of insurance. It's hard to obtain a summary plan description, which I'll explain, and that's why we're advocating for the inclusion of a lot of these documents. So in reality, this American Ortho decision is going to impact a lot of your patients. And so it's very important that you understand the nuances of it, and that will give you a substantial amount of value to making sure that you're maximizing all of your reimbursements. So again, what patients will this affect? This decision affects self-funded ERISA plans. So in the context of, let me give you an example, like Coca-Cola. It's one of my examples that I use a lot. So Coca-Cola doesn't go out and obtain 10,000 policies of insurance. What they do is that they segment out a piece of revenues, however it works, and they deposit it into a completely separate entity. We'll call it the Coca-Cola Health and Welfare Fund. And that health and welfare fund's purpose is to pay for the claims that are submitted for health benefits, welfare benefits, pension benefits, things of that nature. Now, Coca-Cola is great at making juices and sodas and things of that nature. They're not good at processing claims. So Coca-Cola then reaches out to someone who is good, and they go, hey, Horizon, you guys seem pretty good at processing claims. You seem pretty bright on these issues. Can we contract for you to serve as our quote-unquote claims administrator? So Coca-Cola Health and Welfare Fund is the plan administrator, and then they go out and they get the Horizons and the Cignas and the Aetnas, and they go, will you serve as our claims administrator? Basically, you'll release the card of insurance, so that's what they show to the doctors. The doctors know to submit their claims to you, you'll process them, and you'll tell us what we need to pay. And then the Horizons and the Cignas and the Aetnas of the world go, sure, we'll serve as your claims administrator. That sounds great. That's the portion of patient plans that are affected from the self-funded ERISA plans, right? Self-funded ERISA plans. But in addition, ERISA also governs a large amount of employer-sponsored health plans, right? So virtually, nowadays, virtually everyone gets their policies of insurance from their employer, right? Nobody who is employed goes out, for the most part, and gets their own policies of insurance. Sometimes spouses will go on to the plans of their husbands or wives. and get, you know, a spousal coverage, and then the children will be covered under the families. But these are all employer-sponsored health plans. So the self-funded plans, the Coca-Cola Health and Welfare Funds, and then your employer-sponsored health plans, for the most part, will be governed by ERISA, and that's the universe of patients who will be impacted. And so, given that introduction to which of these plans are actually being impacted, I think we can all start to get a feel for just how many of your patients are going to be impacted by this decision and this new strategy to ensure that you are, you know, maximizing your reimbursements. So again, self-funded ERISA plans, employer-sponsored health plans governed by ERISA. And you know, a lot of providers ask us, well, how do I tell the difference? It's really confusing. Which one's a fully funded? Which one's a self-funded plan? How can I tell? Does the card say something? Do I, you know, where do I obtain these documents? And for the most part, it's very confusing to figure out whether something's fully funded plan, meaning that it's underwritten by somebody like Horizon, right, an entity like Horizon, which then bears the risk of loss and has to pay the benefits directly if a claim is made, versus the self-funded plans like the Coca-Colas or a Union Health and Welfare Fund, which pays for the benefits in case someone is injured. And so, you know, call up these insurance companies, they're gonna give you a hard time in trying to figure this out. But the answer, for the most part, is actually on the card of insurance, right? And I'll show you that in just a second. But when it comes to the self-funded health plans, remember, this is the ERISA plans. This is what's going to be governed by the bulk of our conversation here today. You can absolutely figure it out by obtaining a copy of a very critical document, which not a lot of medical providers are getting their hands on, which is referred to as the summary plan description. The summary plan description is the most critical document, and many providers don't even have access to it. The plan itself specifically tells you what the reimbursement is going to look like. So a lot of providers will call up and say, hey, does this patient have coverage for this procedure? And they go, yes, absolutely. And then they hang up the phone, or they ask for pre-authorization. They don't ask the next follow-up question, which is, how is it reimbursed, right? And then sometimes you'll hear, oh, it's reimbursed at 150% of Medicare, or 130% of Medicare, or some percentage of Medicare, or it's reimbursed at some percentage of Fair Health, or it's reimbursed at a UCR rate. The way to figure out what the reimbursement scheme called for, the only way to figure it out conclusively is to get the summary plan description, which is the actual plan document. So in the same way you would request the policy of insurance on a fully funded health plan, the summary plan description, the SPD, is the document that'll tell you how to get reimbursed. And so it may be sometimes difficult to figure out. And not only that, but sometimes the insurance companies don't even have the self-funded the summary plan description, and they'll say, oh, it's reimbursed at 150% of Medicare, and the truth of it is that the SPD says something totally different. It was updated to say something totally different. So you may be providing a procedure, believing you're being reimbursed at UCR, some percentage of Medicare, and it turns out that there was an amendment which the insurance company didn't account for, and then suddenly you're getting a refund request form or an overpayment request form, which many of those, by the way, you know, we fight those things tooth and nail, and we prevail on a great deal of those reimbursement request forms that you're getting. A lot of medical providers, and I don't know why they do this. It's kind of strange. They're just like, oh, I guess, okay, I have to make a refund because of, you know, I got this letter, and they don't fight it. And then they're losing tens, if not hundreds of thousands of dollars not fighting these refund request forms, which could be based on incorrect information that the insurance company has programmed into their system. So please, folks, if you're getting those reimbursement request forms, please make sure that you're filing appeals. Please make sure that you're following up on them. And you know, I don't recommend doing this without an attorney. If it's not us, then get somebody else. But you should be represented by counsel on this who can make sure that you're getting your appropriate level of reimbursements. But the key document here to figure out whether or not and who the plan administrator is and what your reimbursement rate is a document called the SPD, and we'll talk about how to get that. But as I said, sometimes these cards actually have the information that you're looking for. And so this is a sample document that was taken from a Horizon patient manual. And if you look at number 12, it mentions something about, you know, a network administrator out of the Horizon service area. This could be an indication that you're dealing with a self-funded health plan and not a fully funded health plan. By contrast, so if you look, you'll see that language in there. It's kind of voluminous, it's kind of complicated, like there's see your benefits booklet for covered services and this entire explanation. But it is possible that this actually is a policy that is self-funded. And so if you look at this card, right, which again, right off the internet, right from Horizon's website, And if you look at the circled area, you'll see it says insured by Horizon Blue Cross Blue Shield of New Jersey. That is a very powerful indicator that this is a fully funded health plan. And so governed by, the out-of-network legislation that just came up, it's probably a policy of insurance or something along those lines, which is fully funded and not a self-funded health plan. So that's one of your indicators to figure out what kind of policy you're actually dealing with. Always check the cards, always flip them over, take a look at whether or not it's a fully funded or self-funded health plan. But I will say this, I recommend having one policy, right? One process by which you process these claims. And so that process should include a determination about whether or not it's fully funded or self-funded. I would not create a separate process for processing your claims, whether it's self-funded or fully funded, because it adds too much confusion to the practice. One process on doing these things, but some things may have to change the documents that you use and things of that nature if it's self-funded versus fully funded, but this is probably one of your best indicators as to what you're dealing with. So going right into the meat of what we intended to talk about today is the power of attorney, right? So over the past few years, there has been this escalating trend towards plans, right? Summary plans, including these anti-assignment clauses. They become more and more common, and the courts have been more and more ready to enforce these anti-assignment clauses. And so what actually happens is you have a medical provider who files an appeal or a medical provider who files a lawsuit, sitting in court, ready for his day in court, and then a motion to dismiss is filed saying that the provider doesn't have standing. Provider steps up and goes, I have an assignment of benefits. Of course I have standing to assert my claims. And the district courts are basically saying, no, you don't. There's an anti-assignment clause in here. And so when the patient assigned his benefits to you, he was in violation of this contract. And so I'm going to find that this anti-assignment clause is valid and enforceable, and thus your assignment of benefits is invalid and unenforceable, and thus you have no standing and goodbye, right? So you lose your day in court. And so we took one of these decisions up to the Third Circuit. I think it was back in 2017. We took it up to the Third Circuit, and we argued in front of the Third Circuit that these anti-assignment clauses should not be enforced against the medical providers, right? The ERISA statute was specifically silent on this issue, and this has been the pattern of practice of most medical providers across the country to obtain assignments of benefits. And this would literally throw a monkey wrench and violate all of the principles that we've established through the law and through fairness and justice here, that the medical provider should be able to should have standing under these assignment of benefits, notwithstanding an anti-assignment clause. We argued under policy considerations, saying how unfair it was. You're basically making the least sophisticated person in the transaction enforce their rights, which they're unlikely to do, and putting the medical provider at odds with their patients in trying to collect on their bills when they know that the insurance companies reimburse something incorrectly or wrongfully, and that the patient is the one who then has to pursue these claims. And they're less likely to do that. And then you have providers needing to sue their patients. It created a whole ugly dynamic. But the reality was that the Third Circuit really wasn't moved by that. And many, or at least with regard to this issue, and many of the other circuit courts, such as I think the Third, the Fifth, the Ninth, the First, virtually all the other circuits that have spoken on this issue have all came down in the same conclusion. These anti-assignment clauses are enforceable when included in these self-funded health plans. Generally, right? There's still a tax to them in the same way you can attack any kind of contract, but they're drafted up by an insurance company. It's tried and tested, and for the most part, their anti-assignment clauses are pretty ironclad, right? There's challenges that you could still make. You could argue that they waive their rights. You could argue that the contract itself or the language itself is unenforceable for a variety of reasons. But by and large, the district courts were dismissing cases against medical providers, and medical providers were left with no recourse but to sue their patients or to eat the bill. And so we went up to the Third Circuit, and the Third Circuit basically spoke. And what they said was, look, we join with our sister circuit courts on this issue, and we find that generally speaking, anti-assignment clauses are enforceable, and they can defeat an otherwise valid assignment of benefits. So the same assignment of benefits that you're using in state court, right, to collect on your claims in PIP arbitrations or workers' comp court to collect on your bills, which is valid and enforceable in state, is now rendered invalid and unenforceable by the anti-assignment clause. And generally speaking, we, the Third Circuit, believe that notwithstanding all of the policy considerations and all the arguments and all the reasons why we should not find them to be enforceable, the anti-assignment clauses are enforceable. But then the insurance company tried to go a step further, because what we argued was, look, even if there is no assignment of benefit and it's rendered invalid, the patient has a power of attorney. And the power of attorney is different than an assignment of benefits, and the anti-assignment clause can't prevent you from getting a power of attorney. So that's what we had argued. The insurance companies basically argued, like, they're all the same things, right? Power of attorney, anti-assignment clause, functionally there's no difference between the two of them. The anti-assignment clause speaks on this issue. You're not allowed to have powers of attorney the same way you can't have anti-assignment clauses. And so, again, the Third Circuit spoke initially and said, yes, the anti-assignment clause itself is enforceable against assignment of benefits, but Mr. and Miss Insurance Company, not so fast on the issue of the power of attorney. This is some specific language that they use in terms of the insurance company's arguments that, hey, look, it's enforceable against power of attorney, it's enforceable against assignment of benefits. And the Third Circuit spoke and specifically said the insurers are mistaken. And the clear language that they use is to the contrary, right, of their position. Because he, referring to the patient, retains ownership of his claim, the patient, as the principal, may confer on his agent the authority to assert that claim on his behalf. And the anti-assignment clause no more has power to strip, in this case the appellant, the medical provider, of its ability to act as the patient's agent than it does to strip the patient of his own interest in his claim. That is the key language at issue here, and rocks the insurance companies. In the same way that we rocked the insurance company in the Mirza case in 2015, we have now rocked the insurance companies in terms of their ability to rely on these anti-assignment clauses, which they became the gatekeeper of medical providers filing these claims. So the Third Circuit spoke resoundingly, and has basically endorsed this practice of the use of the powers of attorney to confer standing onto the medical provider, right? So huge resounding victory, super proud of it. Came down May of 2017. If you guys want a copy of it, we'll attach it as part of our YouTube submission. I'll also attach these slides so you don't have to take notes or anything along those lines, but we'll upload all of those to YouTube as well so you can access them after this webinar is over. So basically, what does that mean to me, right? That was a whole lot of legal jargon nonsense, Mike. What do I have to do? So what does this mean? Basically, the anti-assignment clauses will become a boilerplate addition to virtually all self-funded health plans. And so that's why, we kept with the principle of evolve or perish, that if you don't change your practices and conform with the law and start obtaining these powers of attorney, you're going to end up in a situation where you're unable to collect on self-funded health plans or to enforce your rights either at the appeals process or in court. And so, we're recommending that you appropriately obtain powers of attorney, that you discuss, the matter with your patients, and that you begin obtaining these powers of attorney to ensure that you're conferring standing onto yourself to start collecting your out-of-network benefits and maximizing all of your benefits. And so we're heavily recommending the power of attorney in addition to those other documents we talked to. But again, I'm reinforcing this fact. Please do not stop obtaining assignments of benefits, because they can still be utilized in other contexts. It's just in the self-funded context where there is an anti-assignment clause, which is in a lot of plans, the assignment of benefits will still be useful. It's just they're not useful when you have the anti-assignment clause. So again, that's great. What do I need to do? Again, it is a legal document, no different than the assignment of benefits, but it has certain different language, certain key language, which we're happy to provide you with templates for. What's different about the assignment of benefits, and this is a nuance to it, which is very important, that in order to perfect it, you have to have a witness on hand. And in this case, we recommend having a notary in your offices. It's not difficult to obtain a notary. There's a fee that you pay, and you get licensed to do it, and it is not a difficult process. I think it took some of our providers a week or two to make sure that they got multiple notaries inside the office to notarize these documents. But that's the biggest difference in terms of just the procedural part of getting these powers of attorney, is the having to notarize the document, making sure that the patient understands their obligations and things of that nature. But the notary just makes sure that the the document itself is appropriately, the signature is appropriately there, and that it's the person who is representing themselves to be the patient in this situation. You also want to make sure that you have the right power of attorney, right? You want to have a limited durable power of attorney that is limited in its scope. And so the scope of that should be for the medical services that you provided, and certain other rights and abilities to file suit, to file appeals, to collect documents and information and things of that nature. It's a 1 to 2 page document maximum, but it has all these powers inside of it. You want to make sure that you have those. And just to keep in mind that there's a slight difference in the relationship between the assignment of benefits and the power of attorney, because the medical provider is then acting as what's referred to as an attorney in fact, which anybody can be a power of attorney. There's certain limitations, but people can act as a power as an attorney in fact, that you do have certain fiduciary obligations to the patients within the context of what services you're saying that you're going to provide as the attorney in fact. In this case, we're referring to a limited power attorney, which focuses on the services that were provided by that medical provider specifically. But there are certain duties and obligations. But besides that, substantively, it confers basically the same rights that existed under the assignment of benefits, except you'd be suing in the name of the patient on their behalf, which gives you all of the benefits of the ERISA statute when you're suing as a participant or a beneficiary, including what our belief is, $110 a day penalty if the plan administrator fails to provide a copy of the SPD. That's the document I've been talking about, the policy of insurance. If they fail to do that after a certain period of time, there's a $110 penalty that's assessed against the plan administrator, which is a powerful piece of leverage to make sure that they're providing you the information that you're asking for to get the answers that you need, and making sure whether or not you've been reimbursed appropriately for the services that you are providing. And so in addition to the power of attorney, which again, upon request, we can certainly have a discussion with any of you. We can provide you with certain documentation that shows you what a power of attorney should look like, and these other documents, the HIPAA Release Forms and the Authorized Representative Forms. You should be informed. You must be informed, and you have to be going out and getting your SPDs, right? The summary plan descriptions on these self-funded health plans. The best way to get them, right, is to make sure that the patients are signing over these documents, the HIPAA Release Forms, the Authorized Representative Forms, but maybe even having the employee themselves go to their employer, right, and get a copy of the SPD, or maybe they even have a copy of it. For the most part, when someone starts a job, maybe they're provided a copy of the summary plan description, but make sure the patients are bringing these documents into you. It's a whole lot easier than reaching out to the insurance companies. With the HIPAA Release Forms and the Authorized Representative Forms, you should be getting these documents, but it's so much easier to get it directly from the patients, or have them ask their employer and forward it over to you, and keep good documentation regarding these summary plan descriptions. The other thing is, and this is really critical, this is slightly outside the nuance of the powers of attorney and making sure that you guys have standing on your out-of-network claims, but the appeals process is something that's really important. Under the ERISA statute, at minimum, there has to be 2 levels of appeal that's available to for self-funded health plans. These appeals processes, are viewed by a lot of medical providers as just a hurdle that you have to get past before you can file a lawsuit. But the truth of it is that these appeals processes, even though the insurance companies may or may not reverse their opinions and make determinations on these appeals, it is actually your opportunity to make your case. What happens is, and this isn't really understood by a lot of medical providers, intentionally so, is that when you get to court at the district level in a self-funded health plan case, is that in a lot of different, in most occasions, you're limited to something called the administrative record. The administrative record is basically what the insurance company or the claims administrator relied on when making their determinations on anything: medical necessity, causation, and the reimbursement, right, that you're getting, whether or not and to what amount you're entitled to reimbursement. When you submit your appeals, you're actually building the administrative record. And if you don't submit your appeals appropriately, which is why we advocate for many of our clients who utilize our services, that we should be doing your appeals, your first and second level appeals, that is your opportunity to make your case. And you may not be able to make your case after that date. So once you submit your 2 levels of appeal, if you try to submit more documentation, they'll reject it and say, you've already satisfied your 2 levels of appeal. Your next recourse is to go ahead and file a lawsuit. So a lot of medical providers are missing a key opportunity of ensuring that their appeals are comprehensive, including all the documentation which they are claiming in support of the medical necessity of a procedure, the reimbursement, appropriate reimbursement level of the procedure. They're missing those opportunities by just submitting these, one-page appeals, basically just trying to get past this hurdle that's created by the insurance companies before they can send it out to their attorneys to file lawsuits or pursue them directly themselves. So the appeals process is very critical. That's why we recommend that we will not work with any client who does not at least give us the second appeal, because in a lot of different ways we may be barred from introducing new documents at the trial level if we don't get to submit them at the appeal level. And we also recommend doing the first level appeals, but if you want to try your first level appeals, you can go ahead and do that, but save us the second level appeal, because that'll give us the opportunity to make sure that we're submitting the best claims, the best proofs, the best support to make sure that we're supporting the case when it is ultimately filed for a lawsuit, and it may or may not, right? It may get resolved before then in a lot of different ways, and that's what the fight that we've been fighting in terms of collecting on behalf of our medical providers. So again, just be informed, get a copy of the SPD, make sure that you're appropriately following the appeals process, and that you're using it as a true opportunity to make your case. So one of the other things that I want to point out, and this decision is pretty well known now. It's cited in many different circuits and discussed by the New Jersey court in a lot of different contexts. But in 2015, we actually had another great Third Circuit decision. In this case, it was a case called In Re Dr. Mirza. And what this case basically talked about was, in the self-funded context, there's certain rules and regulations that the insurance companies have to follow whenever they're putting you on notice of an adverse determination. In addition to telling you, hey, we're not going to pay your claim, or we are going to pay your claim, but we're going to underpay you, they also have to give you information about what the plan appeals process looks like and the timeframes associated with that, and the plan lawsuit or judicial review process and the timeframes for that. And if anybody has ever gotten an EOB or an adverse determination letter, for the most part, these insurance companies, and still this is true today, are not including that information about the appeals process and the appeals process timeframes, and the judicial review process and the timeframes for the judicial review. So we brought this case in 2015 saying, hey, look, they're violating these United States Department of Labor regulations, and the remedy for that, for this violation, is that the appeals process doesn't even begin to run until you're put on notice of these claims. And if the adverse determination doesn't provide you notice about what the statute of limitations timeframe is for the filing of a lawsuit, then we go to the most analogous or most similar state statute that governs, and in this case it would be a breach of contract statute of limitations, which is 6 years. And so we took this up to the Third Circuit. We argued this issue. We lost at the trial level, but then we bring it up to the Third Circuit, and the Third Circuit agrees completely with us. They go, if the insurance company below these regulations, there's no such thing as substantial compliance. They have to follow the law. They're holding everybody else's feet to the fire. When they don't follow the law, their feet are going to be held to the fire as well. And the court agreed with us that if the adverse determinations do not have the appeals process and the appeals timeline and the judicial review process and the judicial review timelines, that the appeals window doesn't even begin to run, and the statute of limitations would go from whatever the contract says, 1 year, 2 years, 3 years, whatever the number is, to the most analogous statute of limitations, which is 6 years. That's why we offer a 6-year review when we look back at some of your claims, because in a lot of different situations, even to this day, the insurance companies are not putting you on notice of what the contractual limitation period says or what the appeal windows say under these plans, and that's a violation of the Third Circuit decision in Mirza, which compounded the violation by the insurance companies of the Department of Labor regulations. So their feet can be held to the fire just as much, and the Third Circuit is very willing to do that. And so, like I said, the appeals period are told if they violate this provision, and the statute of limitations is then extended out to the 6-year deadline, no matter what it says inside the plan. This is overwhelming. Right? This is not easy. First, you have this new Out-of-Network Act, which we talked about at our last webinar and have spoken about at quite a few speaking engagements that goes into effect on September 1st. And now this, right? This is crazy. They're trying to kill me. I'm an out-of-network provider. They're trying to shut me down. They don't want to pay me. They're fighting me tooth and nail on everything. Like, what do I do at this point? Like, isn't it just easier for me to go in network And the truth of the matter is maybe, right? It may be easier for you if you don't want to evolve your practice and you don't want to go through the additional training. And once you get to know the Out-of-Network Act that just went into effect or going into effect on September 1st, and you start to understand the nuances of the self-funded, this is not really that complicated. It seems complicated, right? It seems overwhelming, but the truth of it is that once you get control of it, it's really not that complicated. Under the Out-of-Network Act, you have your disclosure requirements, you have your prohibition of billing, surprise emergency services and urgent services on your out-of-network patients, but you can still collect from the insurance carriers. You have the arbitration process, which is all pretty straightforward, and then you have your, you can't waive your co-insurance, copay, and deductible, which was already the law of the land. And then this, the obtaining of the SPDs and the powers of attorney, it may seem all overwhelming, but once you get your feet underneath it, it's really not that complicated. But a lot of providers are asking, like, what do I do? Do I go out of network? Do I go in network? Do I stop billing out of network services? They're trying to crush me. Do I move to Pennsylvania or Indiana or something and become a doctor there? And the truth of it is, maybe it makes sense for you to go in network, but in a lot of different situations, we're trying to negotiate with insurance companies, and they're telling us, hey, the market is saturated with that medical provider in the area, and so they're not letting them in. And we're hearing from a lot of medical providers that's happening as well. And things aren't going to change. This is what the lay of the land is now. And if you're going to remain an out-of-network doctor, you have to evolve your practice, right? And so that's what we're talking about, the evolution of your practices, right? There has to be an increase in communication with staff and patients. There has to be training and an understanding about how the new out-of-network legislation works with regards to your fully funded health plans, your government plans, your PIP, and workers' comp are not affected. But there has to be an increased communication with your staff from the out-of-network legislation alone, right? But in addition, you talk a little bit about increasing the intake processes. You add a notary onto your staff who can notarize these documents, but there is an evolution to your practice which has to happen, right? That's why we say evolve or perish. There's no middle ground on these things. As more of these plans start to include these anti-assignment clauses in their provisions, you're going to be, you're not going to have the opportunity to file lawsuits. You're not going to have the opportunity to appeal these claims. You're not going to have the opportunity to be reimbursed what you're entitled to. But if you do understand how the new out-of-network legislation works, if you do understand your rights and how to obtain, the SPDs, how to obtain powers of attorney, and how to pursue your claims, your reimbursements may go higher because of the changes in your processes. And you're going to have a lot of your competitors who are deciding, I don't want to learn. I don't want to evolve. I like the way things work. I'm just going to go in network. Or I'm going to sell my practice, or I'm going to join one of these larger groups or something along those lines. And there's no knock to any of the folks who do those kinds of things. But a lot of your competitors are going to be looking to do the same things, and suddenly you're going to have a much larger opportunity to take advantage of patients that are going to be looking for someone of your caliber to provide these procedures. And so update your intake processes, right? Securing the HIPAA release forms, the personal representative forms, and getting the powers of attorney, right? So improve your processes. And in addition to that, we invite everybody to be a part of the Callagy Law Practice Mastery every month, just about. I think the next one is in September. We do practice mastery, where we introduce these kinds of concepts to help you evolve inside your systems. And so this is going to be my 30-minute spiel, guys. How can we possibly help you? We have mastery of the litigation process. We've been filing CI claims for a very long time. We've been successful in the Third Circuit in getting these decisions and winning strategic battles for our medical providers, but we've also been helping them in terms of their appeals processes and making sure to maximize their out-of-network reimbursements. We're helping through our caring urgency aggression to produce unique and efficient results for our clients. We can provide you with model documents to help enhance your processes. We have client liaisons that can assist you in the administrative components of what you're doing. And we have access to dozens of attorneys that can help you with virtually any of your legal issues, no matter what it is. We do all facets of medical revenue recovery, commercial insurance and ERISA claims, your PIP, your workers' compensation, healthcare transactions and compliance. A lot of medical providers are getting these reimbursement request forms that the insurance companies want to be reimbursed for payments that they made to you in error. And we've been really successful in combating the insurance companies and preventing them from collecting a lot of these monies, sometimes to the tune of hundreds of thousands of dollars, and in some contexts, millions of dollars. So, please be mindful of that. We can definitely assist you in that regard. We have a full suite of business, commercial litigation. We have a wonderful family law department. If you have any matrimonial issues, child support issues, things of that nature, we have two certified matrimonial attorneys in-house. that are super fantastic. And we've added a property and casualty insurance group if you ever have any kind of issues collecting on any of these various issues. And so what I said is, please join us for our next practice mastery. It's sometime in September. If you want to find out exactly when it's going to be, you can go ahead and contact Tiffany Shoemaker, who's in the room with me. And here's her email address. And we add new content daily on Facebook and content added to YouTube. And if there's anything specifically that you guys want to call us out on, you have certain specific questions, I'm begging you, please do not sit there and have a question unanswered. I'm happy to answer any of your questions. You're welcome to call us. You can email either Tom LaGreca or myself. Tom's email address is tLaGreca@CallagyLaw.com. And my email address is mSmikun@CallagyLaw.com. My direct dial is 201-261-1700, and my extension is 120. So please, if you guys have any questions, don't sit there and go, forget it, or I'll have it answered later. Pick up the phone today, email us today. We're happy to answer any questions for any of you folks. And I'm sure that there's going to be a lot of questions out there. And if you send them to us by way of email, we'll try to get you a response immediately. So I appreciate everybody's attention. I appreciate everybody participating. And, looking forward to doing the next webinar. We'll announce what the next feature is going to be. We'll get that out as part of our email exchange, but please make sure that you're signing up so that you're getting these email blasts and you know when the next webinar is. So again, thanks folks for participating, and until next time or until the next practice mastery, I'll see you guys then. Have a great day.